Ladies and gentlemen, thank you for taking the time to be with us today and welcome to the M&A Masters program, which is our second webinar in the program. My name is Kingshuk Banerjee. I'm a partner at Khaitan and Company as part of the disputes practice. The M&A Masters program is designed to provide sophisticated education and discussion on contemporary M&A issues to experienced corporate executives, in-house legal teams, investment banks, intermediaries, and others participated or interested in M&A in India today. Our subject today is M&A Disputes Review Case Studies, and on this slide, you can see the agenda for today's webinar. If you do have questions, please submit them using the facility provided in the webinar portal. If we cannot cover all the questions in the course of the webinar, we'll respond to you offline. Please do note that a copy of the presentation and summary notes and a recording of this webinar will be sent to you after the webinar as a matter of course. M&A is an important part of our firm's practice with more than 50 partners dedicated to this area. M&A transactions, while often strategic and lucrative, can also be fraught with challenges, contractual disputes, valuation disagreements, post-merger integration issues can escalate into full-blown litigations. In this webinar, we will discuss three important cases which have or are likely to have a significant impact on the M&A landscape in India. Everyone who has registered for this webinar should have received by email already the profiles of our speakers today and their credentials. Suffice it to say they are all experts in this subject matter and qualified to express views and opinions on M&A disputes. Our presenters today are Sneha Janakiraman, Jyoti Sinha, and Anushka Sharda. Without further delay, Sneha, may I request you to first start, please? Over to you.
Thank you, Kinkru. Good afternoon, everyone. Thanks so much for taking the time out to be with us today. The dispute that I will be discussing today is the one between Anupam Mittal and Westbridge, which has, of course, attracted widespread reporting because it is so typical of a misalignment of expectations between an investor and the founder. Before I get to the issues in dispute, let's take a quick look at the deal overview. Now, what were the facts in this case? The acquirer in this case is Westbridge Ventures 2 Investment Holdings, which is a Mauritius-based PE fund. The target company in this case is People's Interactive India Private Limited, which is an Indian limited company floated by Anupam Mittal and his cousins Anand Mittal and Naveen Mittal. Now, Westbridge acquired a significant stake, about 44.38% in the target company, with an investment of about 166 crores. As is to be expected, it came with a whole suite of investor protection rights. So there was a shareholders agreement and a subscription agreement entered into in 2006 and subsequently amended in 2008. Some of the key features of these agreements was that it allowed the investor exit options in the form of a buyback if the IPO of the company was not consummated within 5 years. Failing a buyback, the investor could compel the exercise of drag-along rights and force the founders to sell their shares to a third party. And of course, the critical piece of this presentation is going to be the dispute resolution mechanism under these contracts. It provided for a Singapore-seated ICC rules-governed arbitration. The governing law of the substantive contract was Indian law, but there was no governing law specified for the arbitration agreement. The rationale for this deal, of course, in 2006 was the burgeoning digital services sector that attracted this sort of investment. Now, things were hunky-dory between 2006 and 2017, which is when the dispute story triggered. But before we get to that, if I could draw your attention to the arbitration clause. Next slide, please. The thing for us to note in this provision, of course, is that it provided, like I mentioned, for a substantive law to be Indian law to govern the disputes between the parties. It laid down clearly that Singapore was the seat. It laid down clearly that the ICC rules would apply, but the key factor that it failed to lay down was what would be the governing law of this arbitration, and I'll tell you in a minute why this is critical. Next slide, please. So in a scenario where investors incorporate dispute resolution mechanisms in the form of arbitration in their contract, typically in cross-jurisdictional disputes, it is critical to bear in mind that there's a multiplicity of laws that actually apply. The first is, of course, the proper law of the contract itself. This is a substantive law that actually governs the rights and obligations of parties, such as was termination rights validly exercised, was there a breach of contract, were exit rights typically validly exercised. The second is the law of the seat. Now, the law of the seat really governs the arbitral procedure, the supervision of the concerned judicial courts, the grounds for setting aside of the award, and such proceedings. But interestingly, in some cases, as you will see with Singapore, the law of the seat could also be deemed to govern the substantive validity of the agreement to arbitrate. Please bear in mind that the arbitration agreement is in itself a distinct and severable contract from the underlying substantive rights contained in the shareholders' agreement or the share subscription agreement. The third point of law, of course, is the governing law of the arbitration agreement. Now, this is the key missing piece in this dispute. Bear in mind that neither the SHA nor the subscription agreement prescribed any governing law of arbitration. So, really, the entire dispute boiled down to what would be the governing law in this case. Because under Indian law, rights in rem, any rights that affect third party rights, such as oppression mismanagement proceedings, are not arbitrable, whereas that is not the case under the laws of Singapore, which is the law of the seat. Now, the last set of laws or rules that apply to such proceedings are institutional rules. In institutional arbitrations, typically parties tend to adopt rules of the leading institutions such as SIAC, ICC, or LCIA. These rules are really aimed at regulating the procedure rather than any sort of substantive validity of the arbitration agreement. Next slide, please. Now, let me take you to what happened in the facts of this case, really, because, and bear in mind, there was an absence of a governing law of the arbitration agreement. In 2017, Westbridge decided to exercise its exit rights and called for a buyback, which the company was unable to fulfill. So in early February 21, Westbridge, along with the other founder directors, called for an extraordinary general meeting to essentially remove Anupam Mittal as the managing director of the company and reconstitute the board. So this led Anupam Mittal to approach the National Company Law Tribunal in India, which is a statutory body that has the powers to adjudicate such proceedings. And the proceeding he instituted was one of oppression and mismanagement by the other shareholders of the company. And the reliefs he sought were to restrain them from interfering with the management of the company and to appoint an independent managing director. Now, interestingly, because the shareholders' agreement had a stipulation that even disputes concerning management of the company would be arbitrable with the Singapore seat, Westbridge approached the Singapore courts for an anti suit injunction against the oppression mismanagement proceedings instituted by Anupam Mittal in India. In the first instance, in March 2021, the Singapore High Court granted the interim anti suit injunction on the basis that the validity of the arbitration clause and whether or not this sort of dispute is arbitrable would be determined by the law of the seat, which in this case was the law of Singapore. And therefore, Anupam Mittal was restrained from prosecuting any proceedings before the National Company Law Tribunal in India. Anupam Mittal, of course, appealed this to the Court of Appeal in Singapore. Interestingly, the Court of Appeal in Singapore concurred with the view of the Singapore High Court, but differed with it on the reasoning on the basis of which it held Singapore law was to be applicable. And that difference was the application of a composite test. Now, what is the composite test? Essentially, the Court of Appeals in Singapore held that it's not just the law of the seat that would determine arbitrability, but also the proper law that governs the arbitration agreement. And in this case, the Court of Appeal took the view that because the parties were aware of the fact that oppression mismanagement proceedings are not arbitrable under Indian law, it is implicit in that agreement that it could not have been Indian law that was to govern the arbitration agreement, and therefore Singapore law, as the law of the seat, would be the law that would apply properly to the governing law of the arbitration agreement. And under Singapore law, because oppression mismanagement proceedings are arbitrable, the dispute was deemed arbitrable and the anti-suit injunction confirmed. Now, parallelly in India, the Bombay High Court was seized with proceedings injuncting the enforcement of this anti-suit injunction that Westbridge has obtained from Singapore. And the Bombay High Court, applying principles of Indian law for grant of injunctions, prima facie found that if Anupam Mittal was restrained from prosecuting these proceedings before the NCLT, he would essentially be left remediless. Incidentally, the High Court does not get into a detailed analysis of whether or not the petition is a dressed up attempt to avoid contractual rights. Bear in mind that Anupam Mittal did agree to have disputes concerning management of the company also arbitrated under his contracts with Westbridge. But ultimately, the Bombay High Court took a view that because under the Indian Companies Act, such disputes could only be looked into in any level of detail by the NCLT, it would be open to Westbridge to raise all of these objections before the NCLT. And on a very prima facie basis, literally based on the pleadings filed by Anupam Mittal, it appeared that the dispute was potentially one of oppression mismanagement. Therefore, it granted an anti-enforcement injunction. Now, on the basis of this order, the National Company Law Tribunal confirmed the injunction, and the proceedings are still pending and ongoing before the National Company Law Tribunal today. Now, this is the conspectus of facts involved in this dispute, which throws up some very interesting issues for potential founders and investors to consider going forward. Next slide, please. The first and most critical one, of course, is arbitrability. When you're dealing with multi-jurisdictional dispute, it's important to bear in mind that arbitrability needs to be tested not just from the law of one jurisdiction, but both from the law of the seat as well as the law of ultimate enforceability. Now, before I get to the practical impact of this, let me just set the foundation on what disputes are deemed non-arbitrable under Indian law. Any rights in rem that affect third parties, any rights involving sovereign or public functions, any rights that are mandatorily non-arbitrable as per statutory provisions such as the oppression mismanagement proceedings here, and anything involving serious allegations of fraud. So examples of such instances, of course, are oppression mismanagement proceedings, matrimonial proceedings, tenancy disputes, criminal law, winding up proceedings, etc. Essentially, the entire category of disputes that go beyond private inter-party disputes affecting any third-party rights is likely to be deemed non-arbitrable, and an award in such situations likely to be deemed unenforceable by courts in India. Let me give you a quick sample arbitration clause to consider before I get into the key takeaways of what the learnings are from this dispute. Next slide, please. Again, by way of caveat, this is simply a suggestive clause, which of course has to be tailored to the facts and circumstances of your case. But the idea really is to simply pinpoint the key factors that you need to bear in mind when you're structuring a dispute resolution clause involving arbitration for a cross jurisdictional deal. First is, of course, if you're going to opt for institutional arbitration, please identify your institution clearly, as has been done in this case with the MCIA rules. Second, choose a seat of arbitration that fits your bill. In this case, from Westbridge's perspective, the choice of Singapore, of course, was the right one because Westbridge is looking to enforce its contractual rights. But again, you need to be mindful ultimately of what is going to be the governing law of your arbitration agreement. So again, elect clearly the governing law of your arbitration agreement. So clause 11.4, for instance, in this case, stipulates that the governing law of the arbitration agreement would be Indian law. And lastly, of course, also elect the substantive law of your contract, because ultimately, when you trigger the proceeding, you need to have your rights and obligations determined in accordance with the law that suits the bill for you. Next slide, please. Some quick key takeaways from this decision, Anupam Mittal, in terms of do's and don'ts for investors in such transactions. First is, of course, clearly define your exit strategies. One of the things that was in dispute here, of course, was apart from the board composition, also the fact that Westbridge wanted to sell its shares to a competitor. So clearly delineate your triggers and when they can or cannot be triggered. Second is your transaction structure and regulatory framework. When you're talking about minority shareholder rights, do not lose sight of the fact that even if you hold a significant stake, Indian company law allows the minority shareholder to trigger statutory remedies at a threshold of 10%. That's fairly low. And that is something that parties investing in Indian entities cannot get out of. So plan for it. Three is anticipate and mitigate conflicts. The primary driver in this dispute, of course, was a misalignment between the expectations of the investor and that of the founders. And last but not the least, of course, is ensure that your dispute resolution mechanism is enforceable. One fundamental flaw in the mechanism in this dispute, of course, is that while the Singapore courts, taking a pro-arbitration approach, allowed for the dispute to be arbitrated, ultimately it needs to be borne in mind the award needs to come into India for enforcement and may not be enforceable. Don'ts, of course, are avoid any vague and exit clauses. Do not ignore the Indian regulatory scheme when you're framing your contracts. And last but not the least, do not assume that arbitration will always work. This is a case in point for when an arbitration may not necessarily work in your favor. Also, ultimately, as an investor or a founder, The idea is for creation of value. So, really, whether it's in a confidential proceeding or in a public proceeding, litigating your disputes is not going to help that. Consider alternatives in the nature of mediations or structured negotiations that could help you with this. I hope you found this useful. Thank you. Back to you, Kingshuk.
Thank you, Sneha. I think that was very, very informative and insightful. One quick follow-up question for you. How do you think this case will impact the choice of seat for Indian parties in cross-border transactions? In your view, do you think this will result in parties reconsidering Singapore as a seat of arbitration?
So, Kingshuk, I think if anything, what the Singapore courts have done here is enforce sort of a pro-arbitration. I mean, bias may not be the right word, but a very strong preference for enforcement of the contractual rights that parties have bargained for. So, I would imagine that parties would still be very inclined to opt for Singapore as a seat if the intention is to enforce your contractual rights. But again, I think it's important to be mindful of how to navigate the regulatory scheme depending on who you are. Maybe as a founder or an Indian founder director, you want the flexibility and ability to approach the Indian forum. So, one of the ways that parties could think about, depending on which side of the table you're on, in terms of bracketing your dispute into a contractual and a regulatory or a non-contractual one, is potentially considering making the company a party to the SHA. The National Company Law Tribunal in India, as well as the appellate tribunal, have in instances where the company has been a party, where valuation disputes and such have been raised, considered those disputes to be contractual and allowed for them to be arbitrated. So, something to think about depending on which side of the table you're on. Thank you.
Understood. Thank you, Sneha. Jyoti, may I now request you to please present your case?
Sure, Kingshuk, thank you. Hello, everyone. Good afternoon. It is a pleasure to be addressing you today on a critical issue in the M&A domain. Our focus today is the Indiabulls Embassy merger, a case that highlights key legal and regulatory challenges in Indian M&A transaction. This case presents an interesting confluence of valuation challenges, shareholder rights, and regulatory oversight, ultimately requiring judicial intervention at the highest levels. Over the next few minutes, we will discuss the background, legal battles, critical rulings, and key lessons for corporate executives, investors, and legal professionals involved in M&A transaction. Giving you a brief snapshot of the deal, the transferee company in this case was Indiabulls, and the transferor companies were two group entities of the Embassy Group, NAM Estates and Embassy One. The transaction, which was a merger, aimed to create one of the largest listed real estate development companies and ultimately ended up doing so. The share swap deal, where Indiabulls shares were valued at rupees 92.5%, the details are on your screen. The legal framework entailed the transaction to be executed through a court approved amalgamation under sections 230 to 232 of the Companies Act. Post merger, Embassy Group acquired, along with existing public and institutional shareholders, 44.9, which is a majority stake in the entity. Next slide, please. A brief overview of the dispute, which will help you understand what really happened, what went down. The case involves the approval which was sought to be taken for the merger from the NCLT. There were two petitions filed, one before the NCLT Bangalore, because Embassy Group Companies registered offices is in Bangalore, and another one was filed in NCLT Chandigarh because Indiabulls registered office is in Gurgaon. The NCLT Bangalore approved the merger, the NCLT Chandigarh rejected it. The and NCLT Chandigarh rejection is what we are going to be discussing. Ultimately, the matter then went in appeal before the NCLAT, and which overturned the NCLT Chandigarh's rejection. A further appeal was made to the Supreme Court, which upheld in specific the NCLAT's ruling, clearing the way for the merger. Next slide, please. Now, what were the case highlights and what were the key objections? In principle, there were two objectors. One was the income tax department, who really questioned the asset valuation and the tax implications on the ground that Embassy Group had overvalued its assets in the merger. The other objector was a minority shareholder of Indiabulls, which held only 0.003% shares. The NCLT, while rejecting the minority shareholders' objection, really looked into the issues raised by the Income Tax Department, and in specific, they observed that the Embassy Group had transferred a disputed land parcel to one of the companies, which was subject matter of the merger. The IT department's objection was that the land area was overstated. This impacted the profit sharing ratio, which raised concerns about transparency and ultimately the share swap ratio, which was proposed in the merger. Another aspect which was considered was the valuation which was used insofar as the assets were concerned, and whether the discounted flash cash flow method was correctly applied or not, because the assumptions which were made thereunder were questioned by the IT department. The basis for rejection of the merger by the NCLT was largely on 3 points. One, that the valuation reports that were submitted were deemed unreliable. There were independent valuation reports. However, the key basis for the rejection and non acceptance of these reports was that the information on the basis of which these valuations were conducted were in fact provided by the group companies and the management, and therefore it was unreliable. The NCLT also relied on the ICAI and IBBI valuation standards and observed that these were not followed, and thus they held that there were serious concerns about misrepresentations of the key financials, as a result of which the rejection entailed. Next slide, please. The matter was then moved to the NCLAT and thereafter to the Supreme Court. The NCLAT, after going through the material and the details, observed that Embassy Group was not aware about the reduction of the asset because it was in a transaction with a third party who was supposed to acquire the land and who had not informed Embassy Group about the reduction in the area at the time when the merger documents were filed. This, thereafter, when Embassy Group noted this, they also did a reworking of the profit sharing ratio basis the development rights that they had in that project. And on that basis, they informed the bench that the share swap ratio and the ultimate effect on the valuation of the shares would not be affected even if the land valuation was reduced. As a result of this, the appellate tribunal felt that there was no material suppression of facts in the valuation, there was no fraud or illegality which was found, and in the absence of such fraud or regulatory violation, courts should generally defer to commercial wisdom. They also recognized that the valuation was conducted by recognized expert using standard methodologies. Lastly, they confirmed the NCLT's position regarding the minority shareholders' objection that this cannot override a merger which has been approved by 99.998% of the shareholders. The Supreme Court finally, in its ruling, upheld the NCLAT's ruling and specifically held that the valuation concerns that were raised were correctly dealt with by the appellate tribunal. Next slide, please. This decision leads to several legal principles being framed that eventually led to sealing of the deal. The key ones which I would like to highlight are the regulatory compliance. The appellate tribunal noted that a deal of this size, a merger of this size, had seamlessly gotten the approval of major regulators such as SEBI, CCI, and also had overwhelming shareholder as well as creditor support. The next point that is important is the valuation methodology which was used. That is the discounted cash flow method, which is a method recognized world over, and for real estate transaction, it applies because it generates the cash flow on the basis of future uh, mechanics and not on the basis of a valuation which is conducted of the asset as of today. This was something that the NCLT had not followed. The appellate tribunal also held that the valuer's responsibilities are key because they are required to verify the underlying financials. While they will always rely on management provided data, they are supposed to verify the underlying financials and not simply rely on the data or the projected valuations which are provided by the companies. They also affirmed the valuations which were conducted, and as a result, one of the principles that was laid down was that the valuation reports which are done and carried out independently must be looked at as such. Lastly, shareholder rights, whether a minority shareholder with such an insignificant stake could object to the merger, especially given the nature of Section 230, subclause 4 of the Companies Act, which requires that at least 10% of the uh, shareholder should come together to be able to maintain such an action and a minority objection. Next slide, please. From this, we move on to the key takeaways. The most important probably is the one which is mentioned last, that courts must defer to commercial wisdom. What really is highlighted in this case is that in a situation, unless fraud, illegality, or procedural lapses are proven, courts would avoid interfering in such a transaction. Therefore, what is important as a key takeaway in this regard is that in a transaction where there is overwhelming shareholder approval, where there is overwhelming regulatory approval seamlessly, then the grounds for the court to interfere in such a situation are very, very limited. However, this also leads to a situation where if there are certain serious regulatory concerns, such as in the case in the present case where the income tax took an objection, that does not guarantee an outright tribunal clearance. Secondly, for companies and entities, it is important that an independent and transparent valuation be done. Parties must engage SEBI registered valuers and follow recognized valuation methods, such as the DCF method, which was followed in this case. If required, and depending on the deal size, it may be effective to also have two different independent valuers or more. It must be also ensured that the valuations reflect market realities and withstand regulatory scrutiny. Internal projections, while can be done, these are alone not sufficient, and therefore independent verification is key. Secondly, and as highlighted earlier, regulatory compliance is essential. All steps must be taken to obtain these compliances well in time and have them as seamlessly with clear documentation to prevent any procedural challenges. One other concern that must be noted is that if in a situation like this, where approval of different NCLTs are required, one approval may not guarantee others. There could be legal hurdles, and therefore, steps must be taken to safeguard those. Lastly, minority shareholder rights have limits. This is something that has been highlighted by this particular case. However, given the fact and the deal size, it was essential that something of this sort, if aware to the parties, must be tried and nipped in the bud. Otherwise, these create unnecessary hurdles to a very seamless transaction. With that, I come to the end of my presentation. Thank you for listening in. Over to you, Kingshuk.
Thank you, Jyoti. I think that was well explained. Uh, one quick follow-up question for you as well, Jyoti. The MCLAT in this case emphasized that commercial wisdom of the majority should prevail, and that was really the basis in overturning the NCLT's rejection. But how does this principle balance with the need to protect minority shareholder rights in M&A transactions, particularly when valuation concerns are raised by regulatory bodies? I know you briefly touched upon this, Jyoti, but if you can just elaborate.
Of course. And thank you for the question, Kingshuk. The principle of commercial wisdom of the majority, which the court has really dealt upon in this case, largely entails that the courts and tribunals should defer to the business judgment of a company's shareholders and directors in an M&A transaction. This acknowledges that parties are best positioned to assess the potential benefits and risks of a proposed deal. However, this principle is not absolute and must be balanced against the need to protect minority shareholder rights. The, the key takeaway in this regard is that the court and tribunals must strike a balance between deferring to commercial wisdom of the majority and ensuring that any concerns, including regulatory concerns, such as the one in this case where the income tax had raised valuation concerns, are looked into. Now, in a case where, let's say, there was no regulatory challenge which was faced, then of course the court would simply go by the decision of the majority. In this case, while it was noted that the valuation concerns were unfounded, the court did delve into it and found and ultimately found that they were not required. However, this is the balance that the court and the tribunals are required to strike to ensure that the interests of the minority shareholders are protected.
Thank you, Jyoti. Thank you very
Thank
much.
you.
Anushka, you're next.
Thanks, Kingshuk. Good afternoon, everyone, and thank you so much for taking out the time to join this webinar. I'm going to be discussing the judgment of the Constitution Bench of the Supreme Court of India in the case of Cox and Kings versus SAP India, where Supreme Court has ruled on the validity of the group of companies doctrine and its application to arbitration agreements. Now, in this presentation, we will discuss the judgment and its relevance to M&A transactions, key findings of the judgments, the approach of different jurisdictions in application of the doctrine, and lastly, the practical implications of the same for a M&A deal. Now, before we begin, let's understand what is the group of companies doctrine. The group of companies doctrine is used to bind a non-signatory company within a group to an arbitration agreement which has been signed by another member of the group. As such, the group of companies doctrine digresses from the traditional concept of requiring formal consent of parties to arbitrate. Now, in this case, Supreme Court holds that non-signatories can be bound by arbitration agreements under the doctrine provided there is sufficient evidence of implied consent and involvement in the contractual relationship. The decision underscores the importance of assessing the party's intention and the transaction's context when determining the applicability of arbitration agreements to non-signatory entities. The doctrine and the judgment assume significance in the context of M&A transactions as they may result in binding non-signatory entities to arbitrations in M&A deals. Let's take an example. In M&A transactions, multiple entities within a corporate group often engage in negotiations, financing, and due diligence. However, only specific entities may sign the arbitration clause. Now, if a dispute arises post-closing, non-signatory group entities could be bound by arbitration if their involvement in the transaction suggests a common intent to arbitrate. For example, if a parent company negotiates an M&A deal, but only its subsidiary signs the arbitration agreement, a dispute against the parent may still be referred to arbitration if the parent played an active and important role in the transaction. Also, the doctrine may kick in to assist parties in enforcing reps and warranties against non-signatories. For instance, in M&A contracts, sellers often provide reps and warranties regarding the target company's financials, compliance, and liabilities. If a parent or affiliate is actively involved in these representations but is not a signatory, the doctrine could in fact allow the buyer to enforce those warranties against the parent or affiliate as well. This assumes special significance in private equity deals where fund structures involve multiple entities and only one SPV may in fact sign the agreement. Next slide, please. Now, before we move on to what are the key holdings of the judgment, I'll briefly touch upon the background facts in which the reference was made to Supreme Court. The petitioner Cox and Kings entered into a software license agreement with SAP India. The software could not be implemented and Cox and Kings terminated the agreement. Now, SAP India referred the termination to arbitration, and in response, Cox and Kings sought to invoke the doctrine to join the parent company of SAP India to the arbitration. This led to the issue arising of whether the group of companies doctrine is valid in India and can be invoked in the facts and circumstances of this case. Next slide, please. While the Supreme Court didn't delve into the facts of this case, it has ruled on the legal principle of whether the group of companies doctrine is valid in India and in what circumstances can it be applied. The Supreme Court laid down key considerations which will have to be analyzed to determine when a non-signatory company can be bound by an arbitration agreement. Firstly, mutual intent of the parties needs to be looked into. The non-signatory's role in conclusion, performance, or termination of the underlying contract is key to discern intent. Next, participation of non-signatory in the performance of the underlying contract is perhaps the most important factor to be considered. It is commonplace for the terms and conditions of the agreements entered in the course of M&A transactions to be extended to not only the parties involved, but their group companies as well. For instance, shareholders' agreements often provide for certain changes to be effected on the board of not only the target company, but on the board of its non-signatory subsidiaries as well. The purchasers may, for instance, have negotiated to secure a right of representation on the board of the target signatory company as well as its subsidiaries, which would require an amendment to the articles of the respective group companies. Such changes are typically undertaken to be made within a certain period from closing. Now, in case the subsidiary fails to amend its articles post closing, by virtue of the Supreme Court judgment, the group of companies doctrine may be invoked to join the errant group company in arbitration as well. Thirdly, what is the relationship between the non-signatory and signatory? While this is an important factor, we must bear in mind that mere presence of a commercial relationship is not sufficient. If this factor is applied solely, then any related company may be impleaded even when it does not have any rights or obligations under the underlying contract and did not take part in the performance of the contract. The court has therefore in this case cautioned against this approach and cited the decision of Supreme Court in the case of Reckitt Benexa as an example. In the case of Reckitt Benexa versus Reynolds, the Supreme Court was dealing with an application for appointment of an arbitrator. Reckitt India argued that Reynolds Belgium, a non-signatory to the arbitration agreement, should be bound by the agreement due to the group of companies doctrine. Supreme Court prima facie observed that the parties belonged to the same group of companies, but then it proceeded to examine whether there was a clear intention of the parties to bind both the signatory and non-signatory parties based on their participation in the negotiation of the underlying contract. The court held that the non-signatory party, even though a member of the corporate group, did not have any causal connection with the process of negotiations preceding the agreement, and therefore refused to join it as a party to the arbitration agreement. Thus, the participation of the non-signatory party in the negotiation and performance of the underlying contract was held to be the key determinant of the intention of the parties to be bound by an arbitration agreement. Next, we need to look at the composite nature of the transactions. And for this purpose, we need to read the principal and supplementary agreements in a holistic manner. For instance, often parent companies provide a comfort letter or guarantee assuring the seller that the financial obligations of the purchaser will be met. In case such obligations are breached, depending on the facts and circumstances, the purchaser may be in a position to invoke the doctrine to join the parent company to secure effective relief. Lastly, commonality of the subject matter needs to be assessed. If the claims against the non-signatory and the subject matter of the arbitrator's jurisdiction are common, it may in certain circumstances infer intent to be bound by the parties. Now, having considered the various factors laid down by Supreme Court, it is important to bear in mind that the analysis of whether a non-signatory is bound by the arbitration agreement will eventually be dictated by the facts and circumstances of the specific case in question and has to be based on a consideration of multiple factors. No one factor in isolation can be used for invoking the group of companies doctrine. Next slide, please. Now, with this, let's consider what are the implications of this doctrine in cross-border M&A. There is a large consensus in relation to the involvement of a non-signatory in arbitration proceedings when the involvement is based on theories such as agency, incorporation by reference, assignment, third-party beneficiary, subrogation, etc. However, there is significant divergence of view with respect to application of the group of companies doctrine. In addition to India, the group of companies doctrine prevails in major arbitration jurisdictions like the US, France, Switzerland, and the Philippines. However, many jurisdictions are much more restrictive and conservative, adhering strictly to the principle of privity of contracts, such as England, Germany, Holland, Russia, China. Now, it is important to bear in mind that even if the arbitral tribunals determine the law applicable to the contracts and or the arbitration agreement, the application of law is only and only the starting point in their final determination of the non-signatory issues. This is because coupled with the existence of a group, courts and tribunals have to determine the intent of all the parties to be bound by the arbitration agreement. Next slide, please. Now, with this, I come towards the end of my presentation to discuss what are the practical implications of this doctrine for transaction documents. What are the best practices that parties may think to follow? Firstly, clearly define who is bound by arbitration. Precise language should be used in transaction documents to ensure that all relevant parties are either explicitly included or excluded from the arbitration clause. For instance, if it is in the interest of the party that arbitration should apply only to signatories, one may explicitly state this arbitration clause shall apply solely to the parties signing this agreement and shall not extend to any parent, subsidiary, or affiliate unless agreed to in writing. Secondly, parties must conduct a due diligence on arbitration risks, assess whether any group entity has played a substantive role in negotiations, implementation, or performance of the transaction. Purchasers may, for instance, conduct a legal risk analysis on whether the group companies of the target company might be bound by existing arbitration clauses post-closing. Thirdly, it may be worthwhile to structure M&A transactions to manage arbitration exposure. For instance, if you want arbitration to apply to the whole group, ensure the parent company and key affiliates sign the arbitration clause or explicitly acknowledge their intent to arbitrate. However, if you want to limit arbitration exposure, limit the involvement of non-signatory parent companies in negotiations, emails, and meeting records to avoid implied consent. Lastly, specify your choice of law clearly. In cross-border transactions, parties may factor the approaches of different jurisdictions on the validity of the doctrine while determining the choice of law applicable to the agreement. Now, what are the risky practices that people may choose not to follow? Firstly, do not assume that only the signatory is bound. For instance, if a MNC's global CEO actively negotiated an M&A deal, but the agreement was signed only by a local subsidiary, the parent company could, depending on the facts and circumstances, be dragged into arbitration. Secondly, do not ignore the role of non-signatories in performance. Let's take an example. If a parent company provides a guarantee for the performance of a subsidiary, there is a good chance that it may be deemed to have consented to the arbitration. Thirdly, do not leave the dispute resolution clause vague. Avoid broad, ambiguous clauses that might allow courts to infer implied consent by non-signatories. And lastly, do not assume that SPVs automatically shield parent companies. Using a SPV is common practice, but does not always protect a parent company, especially if the parent's executives have actively participated in the deal. With this, I come to the end of my presentation. I hope you found it useful. Back to you, Kingshuk.
Thank you, Anushka, and thank you very much for explaining the group of companies doctrine and its implications on M&A transactions. One question that often is asked, especially given past decisions on this subject, which is that if group companies work as a single economic unit, will they automatically be bound by the arbitration clause?
No, fortunately, we have clarity to an extent on this issue. The Supreme Court has taken pains to clarify that the principle of single economic reality alone cannot be the basis for applying the doctrine. The mere fact of companies belonging to the same economic group is insufficient. What is required is evidence of mutual intention of the parties and the non-signatories to be bound by the arbitration agreement. This, of course, would be a detailed factual exercise which would have to be undertaken before the arbitral tribunal.
Understood. Thank you. This is very, very helpful. We do have time for some audience questions now. We'll quickly move to that. And Sneha, the first one is for you. As a minority shareholder, what factors should one consider when deciding between filing an operation and mismanagement petition or pursuing arbitration under the SHA to protect shareholders' rights?
Thanks, Kingshuk. Um, I think that largely depends on the kind of rights that you're trying to enforce, as I briefly mentioned during my presentation. So, if you're looking to enforce contractual rights and you have agreed to a dispute resolution mechanism contractually, which is arbitration, you're going to be bound by it. Interestingly, the factor that stood out in the Anupam Mittal decision for me was that the High Court didn't get into the level of analysis at the prima facie test stage to see whether or not the petition that he filed was really one of oppression and mismanagement, which was a divergence from the way the Supreme Court dealt with instances of fraud, where there was some level of analysis carried out. So I would imagine in the near future, given India's building to be an arbitration hub, the scrutiny was probably going to be heightened. While I appreciate that there's a limitation under the Companies Act to the level of scrutiny that a forum apart from the NCLT can carry out, I don't think it can be debated that there has to be a limited level of prima facie test at the referral stage. So, in terms of what you can do to enforce, largely depends on the kind of rights that you're looking to enforce. But that aside, think about whether you're really the party that wants the quick assessment. Unfortunately, litigation delays are a reality in India. So, if you are the party that wants a quick enforcement with a quick decision, think about encapsulating your rights as a contractual right. Make the company a party and try and enforce for arbitration by all means. But of course, as a founder director or a party that wants to retain jurisdiction in India for reasons that are obvious from the statutory protections that are available to you, of course, the National Company Law Tribunal is where you want to be to protect your company. Thank you.
Thank you, Sneha. Thank you. Jyoti, there's a question for you. Are you there?
Sure, Kingshuk. Please tell me.
So the question is, in your case study, the Income Tax Department raised concerns about the valuation of assets transferred during the merger. While the NCLAT ultimately dismissed these concerns, what are the potential legal ramifications for directors and officers of companies involved in M&A transactions if they knowingly misrepresent asset valuations to regulatory bodies or shareholders?
Thank you. So, in so far as potential concerns with respect to directors and officers who knowingly misrepresent such information, ideally, directors and officers of a company have a fiduciary duty to act in the best interest of the company and its shareholder. And this, of course, ensures that the accuracy and transparency of financial information is proper. If they knowingly misrepresent asset valuation to, and especially to regulatory bodies such as the income tax, SEBI, or the CCI for that matter, or to shareholders, they could face a range of potential legal ramifications, including civil liability as well as criminal liability. In civil liability, shareholders and other stakeholders could bring civil lawsuits against directors and officers. They could also be held liable for damages suffered as a result of inaccurate valuations. Criminal liability would arise in egregious cases. Let's say for misrepresentation of asset valuation could constitute criminal fraud, particularly if the misrepresentation is intended to evade taxes or deceive investors. And they could therefore face criminal charges, fines, imprisonment, so on. Also, from the perspective of regulatory sanctions, bodies such as SEBI or the CCI could impose sanctions on the company and its directors and officers in charge for providing such false or misleading information. Uh, that is pretty much the scope of the ramifications that could be faced.
Thank you, Jyoti. Anushka, a question for you. What are the advantages and disadvantages of the application of the group of companies doctrine in the context of an M&A transaction? I think you briefly touched upon this, but maybe you can just elaborate.
Sure, Kingshuk. Thanks for the question. So, M&A deals are often complex in nature, and a company which may have signed the contract is, of course, not always the one to perform all the underlying contractual obligations. Now, in this background, one clear advantage of the doctrine is that it can help a party in securing effective relief by joining all the relevant entities in one arbitration and, as such, avoiding multiplicity of proceedings. However, there are certain difficulties also associated with the application of the doctrine. And the first one which comes to my mind is that the doctrine creates uncertainty on the arbitration exposure of the group companies. Who are the entities who are bound by the arbitration agreement is no longer a matter of merely reviewing the signatories to the agreement or checking for any assignment agency or novation. Whether a group company has by its conduct given implied consent to arbitrate is fairly subjective in nature and could lead to protracted litigation or arbitration to arrive at a determination. Another concern with this doctrine is its non acceptance in some jurisdictions like UK, which could potentially lead to enforcement issues. And in fact, there have been cases in the past where the arbitral tribunal has followed the law of the seat and joined a party relying on the group of companies doctrine. But when that award has sought to be enforced in UK has refused to enforce it because it doesn't recognize the group of companies doctrine. So I think that is a significant disadvantage when it comes to cross-border M&As and when we seek to enforce awards across the border. Thanks.
Thank you, Anushka. We have time for a couple more questions. So, Sneha, there's a question and which is partly a comment for you to confirm. Sneha, are you saying that as a result of your case study, the law of the seat and the law of the arbitration and the governing law of the contract should be the same to avoid the situation which arose in the Westbridge case, where there is a legal conflict over arbitrability and litigation in different jurisdictions?
Okay, that's a good one, actually. Um, that's not what I'm saying, but I see where that question is coming from. So, having a common law of seat, governing law of arbitration, and substantive law gives you consistency when you're looking at it from the standpoint of a conflict of laws analysis. So, you're not bogged down by multiple sets of laws applying. It's simple to apply. But remember that sometimes having a distinct law that governs the arbitration with an arbitration friendly seat can be a significant advantage. If the jurisdiction which, for example, let me take the Mittal decision as an example. If the jurisdiction in which the award was being enforced was not India and was, let's say, France, where such a proceeding would have been enforceable, Singapore was the perfect seat. Singapore is pro arbitration. It recognizes arbitrability of such disputes. That was the contractually agreed dispute settlement mechanism. Let's not forget that. And would have been enforceable in France. So you didn't need for the seat, the governing law of the arbitration and the proper law of the contract to be the same. But yes, if in doubt, and really this is an analysis that needs to happen at the stage when you're drafting your contract, to determine the arbitrability in the jurisdiction of your seat and in your enforcement jurisdiction. If in doubt, yes, keep it consistent and keep it with the law that you're most familiar with. But otherwise, I don't agree that as a thumb rule, they all need to necessarily be consistent. Thank you.
Okay, thank you for that. Jyoti, question for you. What are the key procedural requirements under Section 230 of the Companies Act that companies must adhere to when seeking approval for a scheme of amalgamation? And what are the potential legal consequences of failing to comply with these requirements?
Right, Kingshuk. Uh, so the key procedural requirements are really, of course, filing an application under Section 230 to the tribunal. The tribunal would be the tribunal within whose jurisdiction your registered office would be. Ideally, if the registered offices are in different jurisdictions, then two different applications will have to be filed, as mentioned in my presentation earlier, and as happened in the Indiabulls and Embassy case. This application will have to be filed to call a meeting of the creditors or members. The first application will be for that. A notice of the meeting will have to be sent to the affected creditors and members, disclosing the terms, the impact, the valuation report, the interests, all of it, amongst others. Thereafter, once the approval of all the creditors and the members are given by a majority representing three-fourths in value, would then lead to the approval and ultimately the tribunal sanction. And then the filing will also have to be done with the registrar of companies. Coming to consequences of non-compliance would of course lead to rejection of the scheme by the NCLT. It would also entail penalty in situations being imposed upon the company and also officers in charge. And of course, as we had earlier discussed, if there is any misrepresentation, etc., that would entail separate consequences and ramifications. Thank you.
Thank you, Jyoti. And the last question for today for you, Anushka. It is understood that by virtue of the doctrine or group of companies doctrine, the non-signatories can be obligated to arbitrate. However, do non-signatories also get the rights and benefits which flow from an arbitration agreement?
That's actually a very good question, Kingshuk. I think yes, a non-signatory should be entitled to the rights of a party to an arbitration agreement as well if it is compelled to join in the arbitration. However, it's not as straightforward. For instance, Supreme Court has held that a non-signatory can secure interim relief under Section 9 of the Act, but it has added a condition that it has to first be determined that the non-signatory is a party to the arbitration agreement by the arbitral tribunal. Now, as a practical matter, determination of whether a non-signatory is a party to the agreement could be time-consuming and would render the Section 9 relief often redundant. Therefore, I think while non-signatories could derive rights and benefits under the arbitration agreement, it should be borne in mind that the process for securing the same will not be the same as that of a signatory. It is going to be more tedious. Thanks.
Thank you. I hope that answers the question. Thank you. And thank you very much, all three of you, for the presentation. I'm sure the audience found your presentation and case studies very insightful. A lot of learning for me personally. And I think for me, a couple of key takeaways, clearly, given the increased complexity of transactions, a robust and well thought through dispute resolution mechanism is now a necessity. It's not an option anymore. Uh, Considerations like arbitrability of disputes, possibility of third party involvement are important considerations and which are apparent from the cases Sneha, you and Anushka presented. And Jyoti, as for the embassy case, I think it highlights the importance of balancing commercial viability and regulatory considerations. So very, very interesting cases. Thank you once again. Before we close, can I ask each of you in the audience to please respond to the poll slide on your screen to provide your feedback on today's webinar. We take this very seriously as part of our continuous improvement program. Prajay, if you can just put that up on the screen, please. We'll just wait for a few seconds for that poll slide to come up on screen. Thank you everyone for participating and thank you of course to the audience for your attention and your questions. I hope you found the webinar useful and interesting and a worthwhile investment of your time. We certainly enjoyed bringing it to you. After the webinar, as I mentioned, we will send to you a copy of today's presentation, the material, summary notes and a link to the webinar recording. If you will also separately receive a request for your feedback on the webinar. Please take the time to send us your feedback, comments, criticism, and even compliments. We like that. The form takes less than 1 minute to complete. If you're interested in in-house webinar program or any other matters arising from this webinar, please don't hesitate to contact us. Our contact information is on the slide on your screen. Thank you once again for joining us. We look forward to being with you again at M&A Masters. Thanks so much.